Okay, it's officially 11 o'clock. We'll get started with our last but definitely not least panel here in a minute. I just have a couple quick announcements. Some of you might have noticed some tables out in the lobby and hallway there with cases of Sea-Force water. They are yours for the taking if you want to grab a case of water on your way out. A little thank you for staying until the end, perhaps. And thank you to Sea-Force for being a sponsor for our speaker gifts this year and for donating that water. We really appreciate it. I also would like to announce our winners of the exhibitor bingo game. Those of you who participated, we appreciate it, and I know our exhibitors did as well. So for our $50 Amazon gift card, Whitney Wiebe. Woohoo! And then Jill Garcia, $25 gift card. And Amy Bush, $25 gift card. Next year, y'all should play so you win those gift cards. Get more of you on the app. Okay, so our next panel, case law panel. Mike Gershon with Lloyd Gosselink is our moderator today. And I'll just say I'm really quite interested to hear from this panel, and I know from having looked at their general outline that they're going to be ending on a little conversation on groundwater surface water interaction. So I'm hoping we might get to revisit some of the interesting questions that came up in the last panel if time permits. So with that, let's welcome our next panel.
Well, thank you, Leah and the Planning Committee for giving me the opportunity to work with this panel. Y'all have selected some of the most experienced attorneys in the state on these issues. It's a balanced panel. It would take me about 10 minutes to go into the background of each of these lawyers and their experience. Your program provides background on Natasha, Martin, Ed McCarthy, and Drew Miller, the panelists, and I encourage you to review the program if you're interested in their background, the nature of their practice, and the perspectives that they bring to the panel. We have well over an hour of material to get in that we are going to cover in the next 59 minutes, and I'd like for us to launch into it. One thing that the Planning Committee asked of us this year is to do things a little bit different for the case law panel. As you can see on the slide, we're gonna focus on issues rather than digging in on cases and factual details and procedural information that's detailed about each of the cases that have been recently decided or that are pending in the courts. You'll hear about those cases through the conversation, but we're going to focus on some issues that are pending in court, that could be headed to court, or that have been recently decided. And each of the panelists is going to cover one of the topics, and then we're going to have a roundtable discussion. Let's dig in. On this first issue involving contested permit applications, of course, we're talking about the types of applications where folks are looking to drill a well or get permission to operate that well or produce a certain volume of water. There are a whole host of issues that go into that topic when it's potentially contested. And this next slide, which the picture is of a live courtroom over at the State Office of Administrative Hearings. You've got the various stakeholders in the audience, the experts and their lawyers and the judges there at the front. Natasha Martin is going to tee up the issues, and then we'll have a roundtable discussion about the issues and the cases. Natasha.
Thank you, Mike. All right, and thank you for having me this morning. So as Mike said, Groundwater Conservation District permit applications can be challenged, and we're seeing more and more increasingly they're challenged by possibly landowners, well owners, other permit holders, or in some cases even an applicant will contest a GM's draft permit. So this challenge can come in the form of a request for a contested case hearing on the application. And I'll go over kind of that contested case process, whether it's before the board or hearings examiner, or if it's referred to the State Office of Administrative Hearings. The big issues that we'll see in contested case permit applications is party status, or you'll hear me say standing kind of interchangeably, and venue, whether or not to have it before the board, hearings examiner, or so on. So let's get started with party status. Typically at the contested case stage, the applicant and GM and protestants with standing or the applicant aligned parties that can show standing get to participate. And so these folks have to show basically that they can meet the standards set out in case law and also in the statute. And the Water Code requires groundwater conservation districts to limit the participation in these contested cases to persons with what we call a personal justiciable interest. It further requires that person to show that they would be affected if the permit's issued. And so there's a three-part test that's often relied on to show standing, and that comes from the City of Waco versus TCQ case, and that was a case, I believe, a contested TCQ CAFO permit, if I'm remembering correctly. So 3 parts. You've got to show that it's an injury in fact from the issuance of the permit. The injury has to be 2 things. It's got to be concrete. It also has to be actual or imminent, not just speculative. The injury must be fairly traceable to the issuance of the permit. The last one is the injury has got to be able to be fixed or redressed by the decision. So if the board were to deny the permit application or impose additional conditions. So these 3 parts, they typically track the constitutional requirements imposed in federal courts for standing. So I'm going to jump to what I call the NDOP case. It's the Lost Pines Groundwater Conservation District versus Meyer. And that case kind of didn't really give us some conclusions through the Court of Appeals, but there was helpful information, at least in my opinion, coming out of the SOA proceedings. And so at the SOA level, the administrative law judge found that landowners that did not have a well, an active well, and also in the target aquifer did not establish that first prong of the 3-part test, the specific injury in fact. The landowners in that case said that they did have standing because their groundwater rights would be affected by a district-wide drawdown from production from NDOP's proposed permit. And the ALJ did reject that because he found that district-wide drawdowns would be an injury that's common to the general public. That's another part of the test. It's got to be, the injury has to be specific to you and not common amongst everybody. And so the Lost Pines Board declined to grant standing along the same lines as the ALJ did in SOA's order. This was the first case looking at 36.415 out of the Water Code presented at the appellate level. And the courts didn't answer the standing question. The case was actually decided on procedural grounds. We did get a concurring opinion out of that case from Justice Pemberton, noting that the district board came down on made the right decision in denying, or applied the proper standard in denying the party status. The case has highlighted some issues that we need to clarify. I think one would be to protest a permit, must the landowner have a well or intent to use the groundwater? Second, does correlative rights apply to your standing analysis in determining your particularized injury? And we're going to talk about correlative rights later. And then, should we cover the question, as of whether the district rules should get that detailed into particularized standing and apply or require that an applicant or a protestant have a well? So those are some issues from NDOP. We don't have a decision yet, but we're starting to see some of those creep back up in a pending SOA case, the LCRA case out of the Lost Pines District.
Let me ask Ed and Drew to weigh in on this topic. I know you both have experience, not only when SOA takes a look at the party status issue, but you're in a room, it's board meeting day, there's a permit hearing. whether you're representing the district board, a potential protestant or applicant. From your perspective, what is it that your clients are thinking about if you have an interest in the application, and you may want to participate in it, and kind of real life, what are you doing thinking about proof in this hyper-technical standard that Natasha nailed, but kind of in practice, what is your approach?
Well, first I want to say thank you for having me here. It's an honor to be part of this group. I also want to say, as a point of interest, this past legislative session, Ed McCarthy and I actually worked on the same side of an issue, which was a first. And so, but lest anyone get the wrong idea, it did not have to do with water or groundwater. It was kind of in a somewhat related area. And it wasn't so bad, right? Right, Ed?
What were you smoking?
I didn't think it was so bad.
What were you smoking?
I'm glad that Mike kind of framed that question in the way he did, because actually a fair amount of my experience on this issue of standing has been as an attorney for parties, in particular governmental entities, seeking party status in permit proceedings before GCDs. And also related to that, and I'd like to get to this later, intervening or attempting to intervene in litigation arising out of those contested case hearings, which is related, and Ed and I also have some history on that. But generally speaking, and in most situations, the first issue that I would deal with as an attorney for a party, a would-be protesting party, was to consider and to determine whether my client has wells, first of all. And in the NDOP case, a lot of those folks didn't have wells, which obviously made their situation different and more of a challenge. And I'd like to also comment maybe briefly on that case in a bit as well. But do my clients have wells, and importantly, what's the proximity of those wells to the proposed project under consideration by the Groundwater District? And what's the hydrogeological connection between those wells and the proposed project? Are y'all in a different aquifer completely? And if you are, then you'd want to know that up front. Are there reasonable concerns that groundwater production from those wells will be affected by the proposed project? And what are those concerns based on? Are they based on science? Can you get a scientist to specify and clarify what those concerns are? So what that protesting party really needs to do, and really needs to think about doing from the first moments, is to be able to present evidence to the district or to the SOA judge on those issues in order to justify and establish what Natasha calls in legal parlance a justiciable interest. And it's important, and it's really important to do this and to think about this and to go through that exercise of developing that evidence and getting it into the record, even if there appears to be no opposition to your client's participation as a party. You will want to play it safe and develop that evidence and present it and make it part of the record. Should I pass this to Ed? Yeah, okay.
Yeah, let's. I know Ed has
Get the hook.
some direct experience with the case that's noted under that second bullet point, where there's issues of timing and the nature of the alleged impact. Ed, if you could comment.
Thank you, Mike. Yes, a couple different things. With respect to timing, at what point do you seek to become a party? Most districts have rules that at a minimum, you've got to show up the day of the hearing and ask to be made a party. I've got several cases where it was anywhere from 2 to 7 years after the hearing that people showed up and wanted to intervene. And we don't have any final appellate court decisions, but I'm pleased to tell you that one of the cases listed here is the Bullware case. And that case, the permits were issued 2004 time frame. The landowner applicants sued the district contesting the permits that were issued. In 2007, they reached a settlement agreement. That agreement was brought to the board. It was about to be brought to the courthouse for a final judgment to be entered based upon the settlement and the actions of the board. And the night before, we had a landowner who had not been a party to the hearing, had not filed a specific motion for rehearing, first step in the appellate process in those days before you had to ask for findings and conclusions, intervene. That was in 2007. It wasn't until this past summer that we got that intervention struck. Almost 10 years of delay. And that's a case I think that will go up on appeal. I'm hoping we will get an appellate decision that will give us all guidance. But I think it's important for the district to have in its rules some precise deadlines and drop dead dates. Second case is one that Mike and Drew and I were all involved in out in Pecos County, an application by Fort Stockton Holdings that y'all have heard a little about from time to time. That application process actually started back in 2007. Final application was filed in 2009. Almost two-week hearing was held in 2011. Published notice, personal notice, both by certified mail and the fact that the president of the board was the general manager of the entity that in 2017, when after multiple years of appeals going up and down through the Pecos County District Courts and the Court of Appeals in El Paso, we had an intervention. And there was an intervention. There were two different applications on remand on the appeal. One was to authorize the permit as agreed to by the parties based upon the record that existed. And the second was an application by the applicant, also consistent with the agreement, to reduce the volume authorized under a separate permit. And the intervener tried to intervene in both of those applications, and it was denied. The intervention on the original application was on the basis of it's too late. You weren't here, you weren't a party, it's not time. And the second intervention on the application to reduce the permit amount was on the inability to show any harm. It's very difficult to show how you can be harmed by having a permit reduced and the impacts overall reduced.
I'd like, Natasha, we have a few minutes left on this topic, and then I'd like to move on. It's relatively easy and quick in nearly every district in the state to get an application on file, get things in order, declare it administratively complete, and get set for the next board meeting and a hearing. That hearing can certainly be commenced, ended with decision that day. That can all happen pretty quickly. There are opportunities to take it another route that a number of parties have, whether they want to continue that day and have the matter heard. I'd like for Natasha to comment on kind of what options are, but both from the district's ability to decide how that hearing will play out versus a protestant versus an applicant that may want to go another route.
Sure. So the hearings, preliminary hearings or the evidentiary hearing could be heard by the district board, a quorum of the board, a hearings examiner, but the board has to designate in writing that the hearings examiner can preside over the hearing. The last option that we're seeing more is SOA for some of the cases that have significant interest. And the board generally will conduct the evidentiary and preliminary hearing unless there is a request from the applicant or another party. Sometimes it's even the GM to transfer the matter to SOA or have the district board contract with SOA. And so the timing of that request that is also key, just like the timing of filing your contested case hearing requests, the timing of requesting referral is important. That's something that both applicants and other parties should consider. Whenever something is requested, let's say to go to SOA, I mean, there's certain things to consider when contracting with SOA, with the locations of the hearings, the cost. So if it's a contract with SOA, so it has to be either held in Travis County, the hearing held in Travis County, or the district offices, or wherever the district regularly meets. So something that the board should consider is where are we going to have the most participation? So that's typically in the district. And so whenever you're contracting with SOA, SOA will build in kind of added costs for the ALJs to come out there for travel purposes. As well as if you're requesting referral to SOA, be mindful that you're going to have to put down typically a deposit to cover the costs of the proceeding. If it's just you requesting, you're fronting that cost, but if it's multiple parties, it'll be split. One thing that was, I guess, kind of a common practice before, SOA ALJs would come out to the district and present their proposal for decision, the end recommendation after the hearings. And so they're no longer doing that. Some boards did prefer that, so it was kind of an added support and foundation they could rely on, but SOA is not doing that.
Yeah, and we've got probably a minute and a half left before I'd like to move on. Drew and Ed, could you comment on when that proposal for decision, which is essentially a recommendation by the judge, is laid out to the board, can the board deviate from that? And if so, how, and if not, in what respect? Both on the facts and the law.
Okay. Well, the key issue or the key point is that the board makes the final decision. The ALJ is a recommendation, but the ability for the board to deviate from that recommendation requires that the board find that the administrative law judge has misinterpreted the law or the regulations or the policies and practices and prior precedents of the board or committed some other error of law. As a general rule, that recommendation needs to be followed. There needs to be a clear error to deviate.
Okay.
I'm just going to comment on what I think is a closely related issue that has not been brought up. And we've seen it around the state for a couple of decades, and I think it deserves some explanation. But the issue is, and what we see is a situation where the board of directors of the district, being the decision maker, and the general manager of the district find a need and go ahead and hire separate counsel. And I think this situation comes up regardless of whether the contested hearing is before the district's board or it's before SOA or an independent hearings examiner. And what this is about is and the reason for it is that the general manager is really appearing as a party before the board, and the board is acting as sort of what we call a quasi-adjudicative manner in making a decision on the permit application. The first time this came up, to my knowledge, is in 1997, when the Edwards Aquifer Authority needed to conduct hundreds of permit proceedings, and they identified a need to have what they called special counsel and engaged 3 separate law firms to represent the general manager of the EAA, Greg Ellis at the time, in its permit proceedings, and those were all, they didn't have to be, but they were all referred to SOA. What we've seen since then, where in that case, my law firm, Kemp Smith, was serving as the general counsel of the EAA, and we represented the board of directors, and separate counsel, again, was hired for the general manager. The situations that's evolved since then is to kind of flip that, and so what you see around the state before several GCDs is that the GCD will engage a separate lawyer to advise the board of directors, and the normal general counsel lawyer for the district will represent the general manager in that proceeding. So anyway, that's something that we see. I thought it deserved a little bit of explanation.
Drew, while you've got the mic, let's turn to the next topic. Many of the folks in the room work with districts, whether you're on staff or whether you are an elected or appointed board member. There's concern and assessment of the potential risk of litigation, and when you get sued, there's The preliminary thought is, gosh, you know, how we need to answer the lawsuit. Are we liable? If we have insurance or coverage through the TML program or the TBCA program, you're looking at fundamental questions about, you know, how we're going to cover the costs of the suit and any potential liability. Drew, if you could get into that discussion
Sure.
and some of the cases that are listed on the slide that are addressing those issues.
Okay. Well, so this issue of director liability, the liability of groundwater conservation district directors, it seems it's talked about before. I've talked about it at the Groundwater Summit, and it seems to generate a fair amount of interest at this conference, I think, at least in part because there are groundwater district directors in the audience. And I know you are all asked for a show of hands. That's not me, is it? I turned mine off. You were all asked for a show of hands at the beginning yesterday, so I won't repeat that. But I know that there are several of directors here, and probably some new directors as well. And so it's understandable that this should be something that piques your interest. And I think I'd say, just generally speaking, by way of introduction, when people decide that they wish to serve as directors of a GCD, they probably don't initially imagine or contemplate being named as a defendant in a lawsuit as a result of their role as a director. And I'm sure it's not welcome news to find out that this can happen, and it's really unwelcome news when it actually does happen. What I've done in the past, I did it about a year ago, is I actually surveyed and I tried to identify every lawsuit filed against a groundwater conservation district since 1995, and then figure out among those cases, in how many of those cases were districts, the directors named as defendants. And so I came up, about a year ago, I came up with roughly 40 lawsuits filed against groundwater districts, and out of 40, in 12 of those cases, the directors were named as defendants. And that begs some questions. First being, why? Why are board members, directors named in some lawsuits against GCDs but not others? Are there valid reasons for naming district directors as defendants in such lawsuits? And if so, what are those reasons? Is the practice of suing board members sometimes used as an intimidation tactic? And then another question that comes up frequently is what is the difference between a board member being named as a defendant in his or her official capacity versus their individual capacity? In my view, some of the 12 cases where directors were sued there were clearly reasonable and valid reasons for naming district directors as defendants, and in others, I don't see any valid reason. One of the valid reasons, historically, was if the plaintiff was asserting an ultra-virus claim, then the plaintiff needed to name a director as a defendant to protect the plaintiff from a dismissal. And the reason for that is a Texas Supreme Court case that established that an ultra-virus claim is a claim that a governmental entity is acting completely without authority in an instance. That sort of claim must be brought against a person and not the entity itself. It doesn't necessarily make sense, but it is what it is. But that rule, as of 2015, no longer applies to groundwater conservation districts, and that's because the legislature stepped in 2015. They felt that suits against GCD directors were becoming too common, that they were providing or causing a chilling effect on people fulfilling their duties as directors, and even a chilling effect in preventing people from wanting to serve. And so the legislature stepped in and amended Chapter 36 in a way to make it clear that district directors were immune from such lawsuits. Soon after that law was established, it was interpreted in the City of Conroe versus Lone Star GCD case, and there I think the court's reasoning was good. They said they recognized that this is what the law did. It immunized directors, but it implied, and I think it implied correctly, that those sorts of lawsuits, those ultra-virus lawsuits, could be brought against the district itself. And so the legislature, as the legislature's been interpreted by the Court of Appeals in the Lone Star case, undid that general rule that still applies to other districts, by the way, that when you assert an ultra-virus claim, you have to name the district defendants. So you no longer have to do that when you're suing a district, an ultra-virus claim. So that reason to name district directors, I think, it no longer exists since 2015. I've got more to say, but I don't want to.
Yeah, well, Ed or Natasha, if you'd like to comment on other aspects of immunity, or I know Drew could continue on that. It might be good for the crowd to hear your thoughts on that.
For those of you who are worried by Drew saying that he and I had cooperated, let me put you at ease. We disagree on this issue. The legislation that was passed in 2015 did create state immunity for violations for individual liability by directors in many instances. I disagree with the interpretation about liability for ultra-virus acts. The City of Conroe case was not appealed to the Supreme Court. I think it's still an open question, and I think you may still see litigation there. I also want to say that I think that the state legislation provides no immunity from federal claims, particularly claims under Section 1983 and the preemption clause of the Constitution, which says federal law trumps state law. So I don't think there's complete blanket immunity. So the first thing I would say to you is if you become a director of a district, make sure your district has the best Cadillac version of director and officer liability coverage insurance in place for your protection.
Chubb is a great policy. That's my plug for an insurance. I don't have much on immunity, but there was a question in the Lone Star case about whether or not district attorneys' fees incurred by directors and officers would be covered or recoverable from the other party if the district prevailed. And so that's a question we didn't get an answer to, but we're hopeful maybe at some point that could come out through the legislature.
Right, and just to mention, there is a case winding its way through the federal court system. The case mentioned in the bullet point, Fazzino v. Brazos Valley GCD, that addresses essentially the immunity questions. There are multiple immunity issues covered in that case. In the lower court, the district judge determined that you can no longer sue groundwater conservation districts under what Ed was alluding to, a statute 42 U.S.C. 1983, which allows you, or what has been alleged is that acting under the state laws applicable to groundwater districts, you're violating someone's alleged constitutional rights. What constitutional rights? Usually the claim is equal protection or due process, you're not being treated fairly. Those were the allegations in that case. The district judge dismissed, poured out the defendant on grounds that the district could not be sued in federal court because of qualified immunity. There was an additional argument under the 11th Amendment that districts, as an arm of the state, could not be sued in federal court, making essentially the same argument, which not getting the water that the plaintiff had requested from the district and an alleged taking. That case is set for early October at the Fifth Circuit Court of Appeals in New Orleans, Louisiana. And we'll learn more about those immunity issues from that case in federal court soon. One other issue that's come up from time to time, I believe the Edwards Aquifer Authority has dealt with it, is the question of if there's a takings judgment, who's paying? I mean, obviously the judgment is against the groundwater district, but what does that mean? What are the sources of funds that districts have if the district's going to have to pay that? I know that in one of the cases, if not more, there was an argument from a district, I believe the EAA, that perhaps the state of Texas ought to be paying the judgment because of the essential mandate that the district implement state statute. And I would definitely appreciate Drew's thoughts on that. The other thing that I think it'd be good to hear from another general counsel of districts, Natasha, about is, so you get a judgment that you got to pay. Chapter 36 provides that a judgment of the district may be paid by an assessment. And I have an opinion about what an assessment is and who you would assess, but it'd be good to hear Drew's and Natasha's thoughts on that.
Well, I think the issue of who gets to pay, and in particular whether the state needs to pay, that issue was kind of tailor-made for the Edwards Aquifer Authority. And the reason it was tailor-made for the Edwards Aquifer Authority is because the Edwards is kind of the odd man out, right, when it comes to groundwater conservation districts, because whereas Chapter 36 districts, the 100 or so, some odd Chapter 36 districts around the state, have like a huge amount of discretion on how to allocate groundwater rights, first of all, in the first instance, and also how to consider and what to consider when it comes to granting, denying, or limiting permit applications. For the Edwards, that was all done, that was all figured out by the Texas legislature in 1993. And so when there may have been some fact-finding to be done, such as, well, how much historical use did you have, or how many acres did you irrigate during the historical period? But once those factual matters were determined, what the Edwards needed to do with each of the permit applicants was predetermined by the Texas legislature. And so we lodged an argument on behalf of the Edwards in the Day case, I believe, that, well, if the Edwards did commit a regulatory taking, the state made us do it. And there's actually a lot of good law on that from the, on the federal state context, where states do things that are directed by the federal government, and then they end up taking property. Well, it's the federal government that commanded that action, and it's the federal government that must pay the takings judgment. Unfortunately, the Bragg opinion dismissed, or the Court of Appeals in the Bragg case, I believe, rejected that argument, and that case was never taken up by the Texas Supreme Court. So, I don't know if I guess the other postscript to that is that the Edwards, for the most part, and I'll knock on my wooden chair, takings claims against the Edwards are now over and done with, based on the GG Ranch case. And I don't think we have time to get into that, but that's certainly my position and the position of the Edwards Aquifer Authority, and we certainly haven't seen any takings claims since the GG Ranch case was decided, and that was a statute of limitations case. I think other GCDs would have a more difficult road to travel in making that argument, but I don't put it past a creative lawyer to try to do that.
Natasha, thoughts on that? Here.
All right. So I guess if you're hit with a big bill, the district would have several considerations to make. If the district, through its enabling legislation, can assess taxes on the landowners, that's one option. And so, landowners could not be pleased in that regard. Looking at maybe assessments on permit holders, and there are a lot of considerations there, like would the assessment be kind of proportional to the production, or would it be, equitable across the board. So different considerations, but definitely if it's an assessment, you'd have to justify which route that you decided to go.
Thank you. Ed, this next topic, we'll hear from Ed in framing up the issues. Both, as you see from the slide, we're going to talk about fair share, groundwater allocation, and the associated issue of takings in the event, as a landowner, you're not getting what you believe to be a fair share.
I'm going to start off with the takings and tee that up real quickly because I want to keep that short and focus on the fair share. On the takings question, I think that the law is relatively clear in the sense that a question of takings is fairly fact-specific, but the principles to be used have been set out both by the United States Supreme Court and the Texas Supreme Court. I think that the takings question that's really still on the table is how do you measure damages, okay? Not every takings is compensatory. Every regulatory act that reduces your free use of something is a taking, technically, but that's part of the police powers and that's not compensatable. The question is, how do we figure out what the takings is worth? And the case we all expected that would come up and we get some guidance from the Supreme Court was the Bragg case. And unfortunately, the court declined to take that case, so that's really still the open question. How do you measure those damages? And that's something we're just going to have to see play out. On the question of fair share, this is a big question and a big issue. What does fair share mean is, I think, the first question, and what are the implications of it? The fair share doctrine, or the fair share concept, I won't even say doctrine, concept, as it relates to groundwater, comes from the Supreme Court's decision in the EAA versus Day case, and the courts mentioned that groundwater, like oil and gas, which is the origin of this concept, landowner owns it, they should have a right to access and get to their fair share. That's about as much as I can definitively tell you, because when you go back and look at the oil and gas cases, the doctrine or the concept was not fair share so much it was fair chance or fair opportunity. The court was looking at Railroad Commission proration rules that denied landowners over a common reservoir of oil or gas to be able to get a permit to produce that and not being able to drill a well and get their fair share. Big distinctions. Oil and gas and the laws related to it and the authority of the Railroad Commission include the ability to allocate on a per acre basis with other factors included, not just acre foot per acre or barrel per acre, but they have specific authorization to do that, which we don't have in the groundwater context. In fact, in Chapter 36 and Section 36.002, little d, little 3, the court says that the law that groundwater is owned by the landowner, that concept doesn't mandate, and districts are specifically not required to adopt a rule that allocates to each landowner a proportionate share of the available groundwater to be produced from an aquifer based upon the number of acres of land that landowner owns over the aquifer. We're not going, and we haven't gone, at least statutorily, to a correlatives rights type of system, and that's important. I think you also have to look at that statute in conjunction with Section 36.1132B, which talks about the district issuing permits and then managing the aquifer to the impacts production causes to the aquifer. We're not talking about capping permit numbers like we have in specific legislation for the Edwards. We're talking about giving landowners an opportunity to get a permit, to produce their fair share, and then the district's duty, and the reason districts exist, to manage and regulate the aquifer for the constitutional concepts we're all familiar with. And that means looking at the actual production, because we certainly, just like surface water is over-appropriated on paper, groundwater aquifers could be over-appropriated on paper. And then the district comes in and manages.
Natasha, could you comment on your counsel to your groundwater district clients about fair share and their permitting allocation program?
Sure. So I guess you've got to balance whether or not the issuance of the permits is interfering with the rights of the landowner and possibly the well user. There's a pending case, electropurification. Again, that's a potential issuance of a permit out of Barton Springs Edwards Aquifer Conservation Groundwater District, whereby, the protestants are saying, if this permit is issued, we are not going to be able to access our water because we possibly will have to lower our pumps. And so some things that district boards grapple with is, well, is it a prohibition of getting to your right if you're lowering your pump? That's kind of, it might be an expectation. A comparison that we've used before is, you get a new roof every 20 years or less. So is there an expectation that you would have to lower your pump to reach your water? So you definitely have to balance costs, economic impact, and impacts to existing users. And I think all of that depends on kind of modeling and whether that looks like there's a potential that the well user won't be able to get their fair share.
Let me do this. Our next topic is Drew's topic, and he's going to frame it up. And I see that we've got just under 10 minutes. And I also see that we're receiving some questions that we would like to save some time to answer those questions. Drew, if we could take it to the next slide, and we're back to a topic that our previous panel covered with a group of scientists and a bureaucrat, with all due to Dave. And so let's look at this from the lawyer's perspective, to the extent that Chapter 11 of the Water Code, addressing surface water and defining underflow as part of that state water, surface water, as compared to Chapter 36. And in your experience dealing with the issue in the federal courts, Drew, if you could help frame up really legally what the legal policy perspective is.
Mike, you're killing me by not letting me talk about takings and fair share.
Well, no, we're going to get some questions, and I think you'll be the first to answer.
Okay.
Mark my word.
Okay, well, I was going to, I am involved in a federal case, the Texas versus New Mexico case, before the U.S. Supreme Court. I represent an amicus party in that case, and I was going to kick off this issue by kind of getting into that case, but I think I'm going to take a different tact for a couple of reasons. One is you've heard some about that case, and I think we could sum it up by saying that Texas accuses New Mexico of stealing of its surface water before it gets to the Texas state line through the development and the pumping of groundwater near the Rio Grande in southern New Mexico. So that kind of that's I think all I need to say about Texas versus New Mexico for the moment, and maybe for today. What I want to do is frame up this issue by going to what may seem like ancient history, but really isn't, because I think it's our legacy, and it's a case from the 1950s. It's the Comanche Springs case. The case is, I believe, over 60 years old, but I think it really kind of sets the stage for where we are and what our challenges are and what we're dealing with. So Comanche Springs, I know we've got some folks here from Fort Stockton or the Fort Stockton area. Comanche Springs were unique. They were written about in 1849 as a clear gush of water which bursts from the plain, unperceived until the traveler is immediately upon it, abounding in fish and soft-shelled turtles. So it was an amazing resource since ancient times. In the early 20th century, it became a very popular tourist attraction. But in the 1950s, as a result of the drilling of wells and the large-scale pumping of groundwater for irrigation on nearby property, the springs stopped flowing. There's a water district. There was a water district at the time. The water district still exists, but with some different functions. That water district's role at the time was to provide water that had emerged from the springs to farmers in the area for irrigation. That district sued the landowner and asked the court to enjoin the landowner, the irrigator, from interfering with the natural flow of Comanche Springs. The Court of Appeals ruled against the district in favor of the irrigator, stating that under the law of Texas, groundwater belongs to the landowner and may be used by him at will. So as long as the groundwater was under the landowner could do as he pleased, and to the total detriment of the holders of the surface water rights, established holders of surface water rights, and the surface water rights right holders had no legal recourse. So that's the situation as of the 1950s. That case has never been expressly overruled. What we have, though, since then, are 100-some-odd groundwater conservation districts, all with kind of the right and the responsibility and the duty to regulate groundwater withdrawals. And so, you know, what could they do? What should they do to address? You know, that I know that's an extreme situation, but it's kind of repeated in various places around the state. We have some laws on the books. They were discussed earlier that allow or that mandate actually TCEQ to consider impacts to groundwater in granting surface water rights. But I've done some research, and maybe you all can tell me, but I'm not aware of TCEQ actually doing that in terms denying permits or conditioning permits or limiting surface water permits on the grounds that they would interfere with groundwater resources. And likewise, groundwater districts are supposed to consider impacts on surface water. That's kind of where we are, and I'm curious as to what folks think about what needs to be done to kind of address what seems to be a real problem.
Well, I'd like to invite Leah back up. I know we're getting close to the end, and I don't want to miss the opportunity for some questions. As we heard from our previous panel, the law and the regulations governing this issue of conjunctive use and underflow in surface water is relatively little. I mean, there's not much on the books that provides guidance on how we're looking at this issue of how we define groundwater versus subsurface water where it's subsurface. We heard from our scientists that it depends on studies. Mr. Covis, James Covis, gave us some examples in the Rio Grande and I believe in the San Marcos area where it really came down to the scientists taking a look at the nature of the flow subsurface. And there were some questions raised that I'm going to ask for Leah's help in helping us to prioritize how you would like us to spend our time, because we could clearly spend another few minutes on the topic.
Yeah. There are 3 questions that have come in that I would love to hit, and maybe just staying on this topic and going back to a question that was posed to the last panel regarding standing to challenge groundwater permit applications that impact gaining streams or springs. Do you believe that river authorities would have standing to challenge those in that groundwater surface water interaction setting? Should they? And then maybe even in a different context that we were discussing in terms of, would it go the other way with groundwater conservation districts having standing if you had impacts to the groundwater?
Yeah, I mean, I'll just say briefly, you know, having the experience of representing protestants, including governmental entity protestants, not river authorities, mind you, but other governmental authority protestants who don't have wells, but who sought party status and who got party status before groundwater conservation districts. And I think one of the things we did in that case, and also involved Ed on the other side, of course, was that we looked very closely at the rules of the Groundwater Conservation District governing standing, and we spent a lot of time with our client to develop some clear testimony on how the granting of a particular project, and this was an export project, would cost our client, which was a governmental entity, increase their costs, require them to pass those costs onto their constituents and taxpayers. And so we even though we were not a party a landowner with wells, we were able to, I think, make a good case for party status, and we were granted party status in that case.
Either of you want to chime in?
Sure. I think as, kind of research develops and the models develop, you're going to see more parties attempting to show the injury, in fact, from impacts to surface water, because I think the new GAM sheds a little bit more light on that. And so, if you could show, let's say if you're a water rights holder, that there's not as much contribution of groundwater to the surface water, and that you've got some economic losses, you might be able to show that you've got a harm there.
With respect to standing, I think it's a very fact-specific and case-by-case determination. I'd like to suggest to you, though, that the limitation on groundwater production based upon the impacts to surface water is a slippery slope that opens the door to a huge takings case, because basically you're protecting the state's asset that is then allocated out to the public or individuals through surface water permits at the cost of an individual private property owner. And while that may be a legitimate exercise of the police powers, I think it's one that will be viewed as being compensatory. I think the Edwards Aquifer Authority escaped a huge takings to protect flows coming out of Comal and San Marcos Springs when those suits, legitimate purpose, protect endangered species, again, an exercise of police powers and an exercise of federal law. But it was one that I think was compensatory, and I think that's a lawsuit that we're going to see, depending upon how hard that interaction and impacts to surface water are pressed.
So if it's okay, Mike, I have a lot of questions that are coming in, and I'd love to hit a few more of them. If it's okay with the panelists, maybe rather than have you all respond, we just do one respond just to be able to get through more. Is that okay? Okay, fantastic. So the first one, if a takings claim was upheld based on a GCD decision to preserve existing historical use permit holders, could that cost be passed on through fees to historic use permit holders who benefited from being able to continue to produce that historically produced groundwater? Ed, you have the microphone, so why don't you take that one?
I don't represent groundwater districts, so I think that's a board decision. I think that if you look at it, the optics of it are that's a fair way to do it because those are the entities that are being benefited most by it. But I think the whole question of how districts pass along those kinds of costs is a very open question and really needs more legislative guidance than what's in Chapter 36 about the power to make assessments.
Okay. So the next question, are there any cases in the legal pipeline where the right of capture tenant will be challenged by correlative rights?
I've got two applications, one recently granted and one that's pending at SOA, the Needmore Ranch case and the electropurification case. The electropurification case, in particularly when the project was first started before there was groundwater regulation, we were sued, my client was sued, with the whole desire to undo the rule of capture. So I'm expecting that issue is out there and is going to come up and get litigated.
Maybe Natasha, this would be a good one for you. Do you feel that GCDs are legally sophisticated in their hearing process so as to justify the substantial evidence rule that currently is used as opposed to a de novo standard? And that was something that came up in the legislature this session with Senate Bill 2027. Maybe you could speak to that?
Sure. I certainly think they're sophisticated to consider the issues that they look at, on a monthly, daily basis. But that's part of the issue. Do we want to refer this to SOA? Do we want to have an evidentiary hearing where they're used to building a record, and the record could support later a substantial evidence appeal or challenge? So I think if the district is poised and has presented or has been faced with a lot of hearings, they could probably handle it. But I think if there's any unease, it should be referred out.
If I could add this is just my opinion, but one of the things that I think that's going to be the downfall of the substantial evidence review in groundwater permitting cases are instances where, and this happens particularly at local districts, board conducting the hearing is a concern about the case going too long and limiting the ability to present evidence and establish your record. And I think one of the things you may see in an appeal from that kind of a hotly contested case is that the applicant primarily was deprived of the opportunity to fully present their case, so a de novo review would be more appropriate.
Do you want to chime in on that, Drew?
Well, I'd just say that the levels of sophistication among groundwater conservation districts obviously vary immensely. And I'll also say that there's nothing like a real controversial case to make a non-sophisticated groundwater conservation district become sophisticated really quickly. And of course, what districts finding themselves in that position need is a good lawyer, hopefully with administrative law experience, who can help them get through choppy waters.
Okay, great. I think we're out of time, but we should give these panelists a round of applause. That was a great presentation.